This video is for the entertainment and education of grown-ups only. Viewer discretion is advised. Well, hello there, my friend, and welcome back to the channel. My name is Gavin. This is my channel. I'm going to pull back the audio just a little bit. Don't want to blow your eardrums out. So glad you're with me today. This is the day before Independence Day here in the United States. So tomorrow we're going to take a little break as we celebrate the 249th birthday of our young and great nation. I hope wherever you are that you enjoy yourselves if you're here in the United States, and wherever you are, hope you have a terrific Friday. Today I'm so glad. I am so glad we are back to talk about the case of Miss Maddie Soto. This is a case that really matters to so many of us. When are we going to be able to get some semblance of justice for Maddie, the 13-year-old girl who disappeared? She didn't really disappear, but she was reported missing on February 26th of last year. Now, according to police, I believe them, her mother's on-again, off-again boyfriend, a man named Stephen Stearns, took her life. He's accused of her murder, and he's also accused of a protracted essaying of Madeline over the course of about 5 years, which meant that she was about 8 years old when it all started. It's disgusting, it's horrifying, it's infuriating. And there are two cases going against Mr. Stearns. The first has to do with the essay, and then the second has to do with her murder. What we're talking about today is the first case, the essay. Now, you guys know that I was really worried. I thought that the defense had a very good argument that Mr. Stearns' rights were violated, and I feared that so much of the information that police gathered from his cell phone, from the search warrants they got, I feared that it was going to be thrown out. I felt like the argument was a good argument by the defense. But if we go over to the old internets, give me a second here. If you guys haven't seen this, there's a link down in the description below. This is the case, the public case file. It doesn't have everything, just the stuff that's publicly available. And if we scroll down here, you will see that on the first two orders denying the defense's motions to suppress evidence were filed on the first. These have not been made public on the docket, but thanks to somebody who wants to remain anonymous, I have received a copy of one of those, which is the order denying the motion to suppress evidence obtained from the Google search warrant. So we're going to get into that a little bit today. Before we do, I want to show you this entry into the docket, and that is that the jury trial has been set for the 22nd of this month, 19 days away. And indeed, if you go up here, you will see that, it has been set for, what's the first one? May of last year, then August of last year, then February of this year, then May of this year, and then the 14th of this month, then it was reset to the 15th of this month, and now the 22nd. And we have an order on that, actually. Let me show you. Well, it's an order. This one I did download off of the public file. So criminal appearance order, that the jury trial is to begin on the 22nd of July, 2025 in courtroom 4F in front of Judge Keith Karsten. So, yeah, is it going to happen? I'm actually a little more enthusiastic that it is going to happen this time, because the judge has denied motions that would have I guess prevented it from happening. So it's possible that a mere, what is that, 17 months after the crime of Maddie's murder was perpetrated, we might have a trial that starts. For those of you who are wondering, I am going to do my best with my day job to ensure that I can stream this trial. It will be live streamed, and I would love to be able to watch that with you all. So we will probably be doing that. Okay, let's stop burying the lead, Gavin. Let's get on over to this document right here. This is the aforementioned order denying Mr. Stern's motion to suppress evidence obtained from the Google search warrant. Let's just read it. This matter came before the court upon the defendant's motion to suppress evidence obtained from the Google search warrant filed February 6, 2025, and corrected on April 29th, 25. The court having reviewed the motion, the state's response, the arguments presented at the hearing on April 23rd, the court file, and being likewise otherwise fully advised of the premises, finds as follows. And before we get into the finding, basically, what the argument was, if you guys will remember, is that the investigator, according to the defense, was only given very narrow access to the phone. That's what the defense says, very narrow. The prosecution argued, no, he gave approval along the way. He said, yeah, that should be okay. He gave the passcode, the whole shebang, right? So that was the argument in a nutshell. I mean, not very detailed, Gavin, but we all watched it together. If you are curious about the coverage that we've done of this case, guys, you can see if you can see all the videos we've done, and you'll be able to easily find it on my website. If you go to Maddie's case page on my website and then just scroll, I think this video right, oh, I didn't, let me bring it in so it'll fit here. You can see all of the videos that we've done here, and a lot of those videos have to do with the evidence. Okay, so in fact, here, Fruit of the Poisonous Tree, that is one that we did. Can't believe it's been since April since we've done a video on Madeline Soto. Anyway, okay, Gavin, keep burying the lead. I just want to give you guys, if you're new here, the website is a place where you can go and get a lot of stuff. Okay. Here finds as follows: analysis and ruling. Defendant contends that all evidence obtained through Google warrant must be suppressed. To support this claim, defendant makes three main arguments. 1. The Google warrant relied entirely on illegally obtained evidence. Defendant first asserts that law enforcement exceeded the scope of Mr. Stern's initial consent, retained his phone without proper authorization, and conducted a coerced midnight download. Because law enforcement used the information extracted from the searches to support the application for the Google warrant, defendant alleges that the state cannot justify the warrant under any attenuation or independent source doctrine because the warrant was entirely built on tainted evidence and intentional misconduct. Defendant concludes that the evidence must be therefore suppressed as fruit of the poisonous tree. If you guys will remember, fruit of the poisonous tree is a legal doctrine that any and all information that is obtained subsequent and as a derivative of, meaning directly connected to, something that was obtained illegally, is that thing that was illegal is the poisonous tree, and the stuff that happens next is the fruit of that tree, meaning no can use use. That's a very, very important legal doctrine, because we want our citizens here in the United States, including Mr. Stearns, to enjoy all the protections that the Constitution gives him. And the reason that we want that is because when say he is convicted, when it gets to appeal, we want it to hold up under scrutiny. And the other part of that is we don't want our rights taken away if we were to be accused, especially if we were wrongly accused of a crime, right? So this is a very important legal doctrine. The defense fails to establish, the judge continues, that his searches were coerced or otherwise improper. The evidence makes clear that the defendant willfully and voluntarily unlocked his cell phone and gave it to Detective Tagler on multiple occasions and unequivocally consented to them viewing map data and documenting his search history. Even after Detective Tagler asked if a warrant is needed, defendant nevertheless consented during interviews. And this is what the prosecution contended too, right? Most importantly, defendant gave consent to law enforcement to download the cell phone and to go through the phone. A reasonable person under the circumstances would understand the scope of the consent to include access to all contents that were searched in this case, including call history and GPS data. During interviews with law enforcement, defendant was free to leave. Consequently, defendant freely and voluntarily consented to the searches, and that law enforcement did not exceed the scope of the defendant's consent. This, a reasonable person, is a very important part of the law, right? The reasonableness is a legal, I guess, doctrine. It is a bar upon which the judge has to judge the law. Would a reasonable person under the exact same circumstances believe that consent was given? So it doesn't matter if maybe Mr. Stearns didn't believe that consent was given. If a reasonable person would have believed that consent was given, that's what matters to the law. The state, therefore, is correct in its response that law enforcement relied on information properly obtained during consensual searches of defendant's cell phone to support the affidavit for search warrant. Consequently, the warrant at issue was not tainted and was not constitutionally invalid as the fruit of illegal searches. That's part one. Before we go into part two, I want to see what you guys have to say about that. Remember, if you want me to view your comment, put a GF on it. That will highlight it on my side. So Susan Lewis says, Gavin, I believe I said more than once that the defense arguments wouldn't fly. Are you doing an I told you so neener neener? Is that what you're doing? Perfectly fine. I was very worried that the defense had a valid argument. I was very worried about it. I didn't want it to be true. I was very concerned, man. I have seen cases fall apart because of the improper and sometimes illegal searches, or even just behavior of law enforcement. Not that they did it on purpose, but I mean, remember, law enforcement officers are not lawyers. And even if you are a lawyer, the law is so vast, it's not like you can be an expert on the law. Here in the Commonwealth of Pennsylvania, there are three parts of the Commonwealth statutes that police officers are trained on, but it's not like it's a 4-year degree on those parts of the statutes. So it, it it is not uncommon for police to mess up, and I was really worried about it. So I'm glad, Susan, that it turned out your way. Marie says that she lived in Kissimmee for a long time, 78 to 2020. Yeah, so you probably know the area. I do believe that the trial will be streamed, yes, and when it is, I'm very confident about this. When it is, I will be sure to stream along with you. I'm working really hard with my company to be able to do that. Um, Yeah, I'm gonna try to stream it. It might be that I'm not able to join during the entire thing, but I'll be streaming it. Horror Queen 1988 says, Gavin, I'm sorry, but if I give someone the passcode to my phone, I will be well aware they will most likely do some digging. Yeah, okay. Uh, Lexi says, Gavin, I was recently in the area for a vacation. I had no idea how close Disney and Universal are to where Maddie died. Kills me to know families were having the best day while she was dying mere miles away. Yeah. Yeah, that is a haunting, haunting comment. A couple more before we go. Um, Susan Lewis, yes, I thought I told you so was implied. Yeah, I got it. I got it. That's funny. Kimberly says, what do you think jury selection will be like? Will they do a deep dive to see who knows of the case and who doesn't? Yeah, I think the voir dire selection process will be pretty long. Uh, I don't think that it's going to be like weeks and weeks, but I don't think it'll be a day. I think they'll select the jury over the course of many days. And yeah, they'll ask probing questions. JoJo's Crime Lines and Mysteries. Part of me would love to be on the jury for this case or his next case, mainly in the next one, the murder of Maddie, but the other part of me does not think I could handle seeing the images. You. Um I do worry about jurors. Seeing things like that is awfully disturbing, especially the nature of this first trial. I think that maybe we are a little desensitized societally to the murder side of it. Um, I do like I've sat in one, I've been a juror on a murder trial, and two, I've sat in some trials that are extremely graphic, uh, children being victims and stuff like that. It does get to you. It gets to you, and I'd like to be able to say that I'm completely desensitized to it. I'm not. No, I'm not. It breaks my heart whenever I see something new like that. Uh, I think in cases of SA, I don't think that. Well, I think the jury will have to see some of those photos. 100%. I think they'll have to. I don't think that they'll publish them to the gallery. I think they will be published to the jury directly so that they can see them, which is the way it should be. Um, I have to say, there is a little, well, there are a couple things that came to mind. The first case where I was given access to crime scene photos that were very graphic, autopsy photos that were very graphic, was the Amanda Winkowski case. And it did get to me. It made me lose sleep. It made me, um, yeah, it depressed me seeing those images. They were extremely, extremely graphic. Um, and I think that I've gotten past most of that, but seeing SA photos, that would be something else. The other thing that I was going to say is Joseph Scott Morgan, who I presented with at CrimeCon UK this year, he has been very forthcoming that his career as a medico legal death investigator, it got to him emotionally and psychologically. Seeing that over and over and over again caused issues, which is what made him change career and become a teacher. So, yeah, this do I think I could handle seeing them, but I think there would be a price that I would pay, just like most people. Um, Robin, I'm going to be very curious if Jen will be called to testify. And oh, we should bring up Maddie's picture. Sorry about that, guys. And or if she will be in court. Yeah. One man's trash, thank God for body cameras, could be different outcome. Uh, A similar situation is going on right now in Norfolk County, Mass, Brian Walsh case. Yeah, that's a good place to pause. Okay, let's head on back over here and look at the second part, okay? The warrant application fails to establish probable cause. This is this is the judge characterizing the defense's argument, okay? So, next the defense asserts that the warrant application fails to establish probable cause. To establish probable cause, a supporting affidavit for issuance of a search warrant, quote, must satisfy two elements. First, that a particular person has committed a crime, the commission element, and second, that evidence relevant to the probable criminality is likely located at the place to be searched, the nexus element. A magistrate is not required to leave common sense at the courthouse door when evaluating whether a supporting affidavit satisfies the nexus element and supports a finding of probable cause. Here, the affidavit for search warrant for defendant's Google account provided a sufficient basis for the court to determine that evidence related to CP would likely be found on defendant's Google account. Specifically, the affidavit points to the fact that defendant factory reset his phone the same day Madeline was last seen. Detective Heller also indicated that interviews of defendant were conducted and that defendant consented to a search of his phone. During the search, several files of CSAM involving Maddie were located. Further, the affidavit stated that defendant's images were stored and backed up on his Google account. Additionally, the affidavit further describes that evidence related to interference of child custody was contained within defendant's Google account. Detective Heller detailed that Madeline was reported missing by her mother on February 26th, 2024. Defendant had stated that he dropped Madeline off at Peace United Methodist at 8:40 a.m., although classes did not start until nearly an hour later. However, a license plate reader captured defendant's vehicle tag traveling away from Hunters Creek Middle School at 8:10 a.m. Madeline never showed up to school. The state is correct that at the time the warrant application was filed, it was probable that other information on defendant's cell phone prior to the factory reset was backed up to his Google account, such as GPS data, which was described in the affidavit for search warrant. Based on this ample evidence, which was relevant to the probable criminality likely located on his phone, the warrant application sufficiently established the nexus element. Consequently, the warrant application was backed by substantial evidence satisfying both prongs of Sanchez, which is the case law before. Defendants claim that the warrant failed to establish probable cause is therefore without merit. Defendant further argues that the warrant was overbroad in its time frame for searches. The warrant permitted the search of data from January 1, 2020 to present, yet according to defendant, provided no factual basis for the expansive 4-year period. However, courts often note that CP collectors maintain their materials for significant periods of time, see U.S. v. Perrin. Here, there is evidence to support that defendant was an individual that fell into this category, given that the material was his stepdaughter and that it was located on his phone and backed up to his Google account. Accordingly, the warrant is not tainted for having an overbroad temporal scope. The court also notes that the warrant affidavit was not overly reliant on generalized and boilerplate language about Google services. The state is correct that the implementation of standard language in the search warrant related to the operations of Google LLC is helpful and relevant in the affidavit. The boilerplate language was accompanied by ample case-specific information. Okay. And the third argument from the defense was that the warrant lacked required particularity for digital searches. Judge says in his final argument, defendant contends that the warrant lacks required particularity for digital searches. Defendant avers that the warrant's authorization to search any and all stored electronic communications or files associated with the Google account is impermissibly broad in violation of the Fourth Amendment. To support this claim, defendant cites Riley v. California. However, Riley is inapposite. What the devil does inapposite mean? Inapposite. Definition. Out of place, inappropriate. Okay. Hey, legal professionals, maybe just use common language. Okay, whatever. In Riley, the Supreme Court of the United States held that a warrantless search of a cell phone seized incident to an arrest must generally be suppressed. Riley does not address in a relevant and detailed manner how search warrants must be particularly detailed when authorizing searches of digital data. The state cites U.S. v. Lamb. In Lamb, the defendant challenged the particularity of the warrant when it sought all stored files in original format in individual files. The Northern District of New York noted that although the language does not limit the investigators to seizing only files of CP, the court noted that the actual content of the computer file usually cannot be determined until it is opened. The court held that the motion to exclude that from the trial was denied. Moreover, the court agrees with the state that even if the warrant was impermissible as overbroad, the good faith exception nevertheless applies. The good faith exception applies when a law enforcement officer acting with objective good faith obtains a search warrant and acts in accordance with the warrant and scope. Suppression of the evidence obtained is not appropriate, even if the court later determines that there was no probable cause. Well, that is horrifying. That's scary. But okay, exclusion of the evidence is appropriate in cases in which the affidavit is so lacking in probable cause that reliance on it would be unreasonable. Again, the reasonableness standard. Here, law enforcement did not provide any false or misleading information in the affidavit for search warrant. As stated throughout this order, the affidavit was not lacking in reliance, so law enforcement relying on the warrant was not unreasonable. Accordingly, the court finds that the good faith exception applies and suppression of the evidence is inappropriate. Accordingly, it is hereby ordered and adjudged that 1. Defendant's motion to suppress evidence obtained from Google search warrant is denied. Done and ordered in Chambers, Osceola County, Kissimmee, Florida, the first day of July, 2025, signed by the Honorable Keith A. Karsten. That is the finding. Now, the finding is similar, I would imagine, on the other motion to suppress. When we look at the docket, it does say it's an order denying the defendant's motion to suppress evidence obtained from unlawful searches of cell phone and motion to suppress evidence obtained from unlawful seizure of the cell phone. So there might be other reasons, other case law cited. Nevertheless, both of those have been denied. And as we discussed earlier, the jury trial is set for July 22nd. As you guys know, I am a professional in two things. Number one, I'm a professional quibbler, and I am a professional waffler. Kind of waffling back and forth. Will the trial begin on the 22nd? I'm starting to waffle on that a little bit. Let's see what you guys are saying over here. And let's bring up a photo of Miss Maddie Girl. Okay, let's see. Oh, just refresh. Let me get back up to where I need to be. Carol says, I think it all came down to good faith. Okay. Peggy says the photos are bad enough, but the videos would be over the edge. Yep. Susan says, Gavin, lawyers and judges have to show off their vocabulary. If they don't, they get kicked out of the club. Oh, I'm not even showing that. You got to bring this up. So maybe that is as a non-member of the club, I didn't know what club rules were. They got to use them fancy words. Their fancy words. Do you think Stefan Stearns will think he's so smart that he'll testify in his own defense? No, I don't think so. I mean, the way that you phrase the question, will he think he's so smart that he testifies in his own defense? Guys, I need a new chair. Will he do that? I think his lawyer will give him good advice and tell him to cállate la boca. No opening the mouth. That's what I think his lawyer will advise him of doing. And if he is smart, he will listen. Susie CJ says, Gavin, I met Maddie and Jen multiple times over the years in my son's school. I'm torn about her comment about SA not being evil. Oh yeah, that killed me. She was often medicated and would have difficulty expressing properly. Well, yeah, you would know better than I would. I just that whole thing killed me, and I knew that. I mean, it killed the police too. They were like, "What? What?" So yeah, whew, that one's a tough one for me. Tough, 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 tough. But I appreciate that comment. Hey, Susan, thank you very much for gifting those memberships, guys. I think that we have come to the end of our little Thursday night sojourn together. At least those of us in the live stream. Rewatch crew, whenever you are, I hope you're having a good time. Tomorrow's going to be a fun time for me to spend with the family. However, I am going to spend a little time during the day working on a project that I'm getting ready for you guys. That my volunteers on the Slack channel know about it. It's actually been a harder project than I thought, and it's taken, I think I've been at it about 75 days, but it's getting close, guys. It's getting close, and I hope that you guys enjoy it when it is ready. Oh, real quick, a couple more comments. Jen has changed a lot over the years. Is Jen going to testify? I don't know. She is on the list. Gavin, will he implicate Jen? If he testifies, he might. JoJo saying any word on Jack and Lily or Decker? The Jack and Lily, I'm working with my team to try to bring in a guest, but we haven't been able to reach her yet. Other than the $150,000 reward that's been put up there hasn't been much happening. But there are people talking about it, and I'd really like to talk to those people who are close to the case. I'm not saying I'm not working hard on it. My volunteers are working hard on it. Robin, do you like the backlight? I tried to match it with the lavender shirt that I'm wearing, though I am terribly colorblind. I don't know that I got it right. Cat artist, do you think Stefan will be allowed to bring his root beer barrel candy into the courtroom? I do not know. Wow, that might be the most important question of all. Thank you, Cat. Hey, happy Independence Day to those of you who celebrate it. Hope you have a terrific time. And with that, I will bid you adieu. Thank you very much for spending this time with me, and I will see you on the next one. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.